The $10,056,000 fraud conspiracy charges brought by the Special Organized Crime Unit SOCU against Assistant Police Commissioner Ralston Andrews Jr., Senior Superintendent of Police Merceline Washington, and Assistant Superintendent of Police Marlon Kelman, along with retired officers Paul Slow, Clinton Conway, Claude Whitaker, George Fraser, Mark Gilbert, and Michael Sutton, were today dismissed in the Georgetown Magistrates Court. The fraud charges were in connection with the review of the police force's standing orders. Magistrate Rondell Weaver, in her ruling, pointed to the lack of evidence in the matter. One of the touching points raised by the magistrate in her ruling was a memorandum detailing hours worked by the defendants, the computer use, and other documents which were handed over to SOCU and were in the possession of SOCU at the time the charges were instituted against the defendants. The court was told that these essential documents were never disclosed to the court, which has raised eyebrows in the conduct of SOCU. Further, the magistrate noted that the evidence in the prosecution's case is miserably lacking and missing essential elements of conspiracy. They calmly walked out of the courtroom feeling vindicated. Their attorneys, Dexter Todd and Darren Wade, both said the charges were bad in law.
That was, of course, verified when they disclosed to us the statements. When we read the statements, it was clear to us that I don't believe that this file really went to the Director of Public Prosecution's office. And because if any lawyer sitting and reading these statements can watch five former serving members in their faces and say, listen, I will charge you for conspiracy. How? From the statements alone, there was absolutely nothing jumping out of the meeting of the mind of anybody planning to defraud the police force. So these charges were bound to fail from the beginning. This decision of the magistrate was a very good reason one. And I think we encourage that the court share that reason decision with the fraternity. And of course, to have it in the library because it's a very good judgment. It follows the law. And I believe these are, some of the things mentioned are not new or should not be new to the Director of Public Prosecution's office. And so they, when they were looking and reviewing the statements, should have been looking with that type of eye. Can we establish the elements of this offense? And clearly, they could not.
What is most concerning is that the magistrate identified and called out SOCU for basically hiding evidence. They were memorandums, they were petty contracts. So you cannot claim that these men carried out work without a contract. When there was a contract, they were meeting between the then Commissioner of Police and senior police officials at the time when the revise or the review of the standing orders were being conducted. As my brother, Mr. Todd, rightfully said, what benefited the state at this point is that Mr. Ifanali was able to suspend the Police Service Commission, and we all know, the entire Guyana know, what came after. They were able to put they were able to promote their own people and place them in the hierarchy of the Guyana Police Force, sadly. Sadly that these men who served Guyana with distinction over the year had to go through this trauma.
Todd feels that the charges were quite convenient.
Based on what was disclosed, I hold a personal view that it wasn't rushed because this was a very thick bundle. You had a lot of statements, you had a lot of disclosures made here, and I would think that any police would have had time to do that. But I think the charges were quite convenient. So I wouldn't say rush, but it was quite convenient because it came at a time in which there was a direct intention to stall the operations of the Police Service Commission. So it was very convenient, not rushed, but very convenient, because persons would have had time to put together and concoct these false charges and place before the court.
The court observed in the prosecution's case there exists contradictory evidence of existence of an arrangement between the Guyana Police Force and the 5 defendants in relation to the revision of the Guyana Police Forces standing orders. Further, there was also evidence of such a revision being done in 2019.